Hello everyone, this is John Milburn for LAWS11057 Introduction to Law, and this is week 7 of term 3 2018, and by the time you look at this video we're about to click over to 2019. We usually of course have our live sessions on a Monday evening at 7 p.m. But given that week 7 coincides with New Year's Eve and my experience in the past that it's very difficult, not unsurprisingly, to have people attend that live session, this is a recorded session in lieu of the live session for week 7. So let's continue from where we were at the end of week 6. We were nearing the end of the issues to do with communicating as a lawyer. And we were discussing, you might recall, the art of taking proper instructions from a client, which involves some client management, acknowledgement of clients' emotional concerns, and trying to identify in the context of the legal interview the real issues so that you can provide an appropriate and full response. One thing that is often overlooked when studying law and then initially practicing law is the mindset that you need to adopt in providing, for want of a better term, holistic advice. When I went through law school in the late 70s and early 80s, it seemed to me that the way we were taught, which I think was typical of universities at the time, was to simply teach the law so that you know the law and to some degree you can apply the law, but only in a courtroom type context. So everything was geared up towards identifying a legal problem and providing a legal submission, if you like, in a court proceeding. We didn't talk about alternatives, and we didn't talk about the way in which you should obtain instructions and deal with clients and communicate in a lawyerly manner, for want of a better term. So there's much more to it, and providing holistic advice means that you must consider ultimately advice that benefits your client's overall position. Now, while that may mean going to court and having full litigation, odds are it won't. In fact, statistically, I suspect, and I'm speaking colloquially here, the chance of proceedings commencing and going through to a full trial are probably about 1 in 20. And that's for those proceedings are actually commenced in court. Most disputes don't even make their way into the front step into the front door of courts at all. So when you think about it, most of the work that we do as lawyers involves negotiations short of appearing in a court. So the art of negotiation is something that is important for a lawyer when acting for a client. And in your text, I'd ask you to read from page 331 onwards in terms of negotiation. A current trend that applies in many legal areas of practice is the desire to negotiate based around interests rather than positions. Now, one of the subjects that I've been privileged to take for a number of years now is LAWS11057 Alternative Dispute Resolution. And you might expect that in that unit, we do talk in great detail about things to do with negotiation and mediation and other forms of alternative dispute resolution. Some of those techniques that are used in mediation practice are readily transferable to acting for a client or generally negotiating. So interest-based negotiations is all around what we call principled negotiation. And there are a number of elements to this. I won't go into a lot of the detail, but principled negotiation revolves around the concept that you're trying to negotiate around interests rather than positions. Now, what does that mean? So when we talk about an interest, we're talking about the overall net benefit, if I can use that term, as opposed to necessarily clinging to a firm position at all costs. So in a workplace dispute, for example, the client may want compensation, may ask for reinstatement to a position, but ultimately, instead of money, it may be that what they're really interested in is some form of recognition, some form of ability to proactively be involved in the business or the enterprise in a meaningful way. And money is what we ask for, but it is not necessarily what we want, although it's usually welcome, of course. So when we talk about interests, we're talking about what would ultimately be the appropriate and best outcome for a client rather than necessarily what they're asking for. The two can coincide, but often, surprisingly, there is a difference. So interest-based negotiation is all about trying to identify the appropriate interests of the parties. In a mediation context, for example, a mediator will often try to channel on the interests of both parties in an attempt to resolve the dispute, or assist the parties, rather, to resolve the dispute. So, for example, we have this situation. A neighbourhood dispute. The dispute relates to a tree. One party says the tree must be lopped because it's causing interference to me. The other party says the tree was there before you bought the property. There's no way I'm going to interfere with this tree. I don't care about the damage that it might be causing you or the interference it might be causing you because the tree came first. So we then have two parties that might be locked in arguing a position. My position is the tree has to stay. My position is the tree has to go. So how do you attempt to resolve that type of issue? Well, one thing that we do is we try to work on the interests of the parties. So what do they really want in those circumstances? And often it might be something unrelated to the tree. It might be noise. It might be some other issue that underlies the overall problem. It might be that someone failed to acknowledge the other on Christmas Day when they were out in the yard, or things of that nature. And what might be in the interests of the parties is to resolve the dispute and have a harmonious neighbourhood rather than necessarily worrying too much about the tree. Although, of course, the central issue will always be the tree. So be mindful of the difference between interest-based rather than positional-based negotiation, and do consider principled negotiation within that context. Now, when I studied law, and traditionally lawyers adopt what's called an adversarial approach. The adversarial approach is where you are there to simply fight on behalf of your client, which is part of your duty, and lawyers are accustomed to doing that. But part of the mindset of adversarial approach when used in isolation is that lawyers forget about other ways of attempting to resolve disputes that may be to the benefit of their client. And one that readily comes to mind that's now very well known, but it really wasn't known to any great degree in the 70s or used in the 70s or 80s, is mediation. Now it's of course very common and it's highly regulated. I'm a nationally accredited mediator and I practice in mediation in a wide range of areas, including commercial and family type disputes. But mediation has a structure to it that is well practiced, well used, comprehensively used by good mediators. And of course, we talk about that in the ADR unit quite extensively. But in short, where a mediation is convened, the mediator will go through an opening statement, will invite the parties to present their position on the matter, highlighting probably at the start their positions rather than necessarily their interests. That's a transition that's made during the course of the mediation. Then there's an open discussion, a joint session if you like, where the parties are encouraged to engage with each other in an active way, followed then typically by private sessions where what is said to the mediator in those private sessions remains between you and the mediator as opposed to being presented to the other side. And then we have another joint session and hopefully an agreement. So that's a very brief overview of a typical mediation session, but there are many hybrid versions and there are many ways to approach a mediation session. In fact, there's a lot of work that's typically done before the mediation even begins in terms of the intake process by a mediator dealing with the parties, trying to encourage the parties to think about the real issues, try to think about the best alternative to a negotiated agreement, the BATNA, or the worst alternative to a negotiated agreement, the WATNA, and to think about how the parties would wish to interact with each other, usually face-to-face, but it need not be. It might be separate rooms, which is a shuttle, or it might be using audio-visual technology. So all of these things are variations on the theme of mediation, which in general terms is in contrast to adversarial approach. Now, not entirely. In a mediation session, lawyers who represent parties are still there to represent the parties and to do so to their best abilities. And what that means is potentially taking quite a firm approach. But in order for mediation to work effectively, it needs to be moderated by some degree of realism. And often lawyers are the best allies for a mediator in that they can take their clients aside together with the mediator in the private sessions and discuss realistically where they're at and what they need to do to advance if they don't settle. And often that revolves around some very honest discussions to do with costs and risk. Now, of course, when you're acting for a client, the other thing that you must consider is litigation, which, as I mentioned at the start of tonight's session, is something that was drilled into us in the early days and is still a very important area of practice. Even in a mediation session, it's not a bad tactic to be ready to go to litigation and be willing to show the other party that you're willing to go to litigation. And quite often in preparing for mediation, I'll actually prepare some court documentation, which is not meant to be a threat, but realistically to indicate to the party that if they fail to settle, this is what they might expect your client to do, which helps to provide that other party a better assessment of their best and worst alternative to a negotiated agreement. Of course, all of that's done in conjunction with your client. So the mindset for lawyers now is a little different than it was in the 80s. Why? Because we adopt a more holistic approach. We consider many different ways of resolving a dispute or assisting a client to resolve the dispute, and we focus on the client's interests and not just the client's position. So all of that flows on from taking instructions from the client and being prepared to assist the client by providing advice about these various options that are available and to then follow through. Now, if you're looking at past examinations, you'll see that in some examination questions, I have asked very specific questions that go to the heart of what we've been discussing this evening. That is, how do you give this holistic advice? How do you put it into practice and provide some worked examples dealing with a scenario, a hypothetical scenario? Let's move on to another very important function of communicating as a lawyer, and this is still part of our Week 6 material, and that is courtroom advocacy. Now, we mentioned at the start that practicing lawyers are either solicitors or barristers. I think roughly in Queensland, there are about 9 or 10 solicitors per barrister. That's just the way the numbers work out. And most of the time when it comes to courtroom advocacy, that is the barrister's domain in the, if I could say, the higher courts, whereas in the magistrates' courts, we often have solicitors acting as advocates. So if you're practicing as a lawyer, odds are you'll need to have some advocacy skills. So what's the most important thing that I can recommend to you in terms of courtroom advocacy? Number one, and probably number 2, 3, 4, 5, is be prepared. Be prepared so that you can identify initially, very clearly, in the first 30 seconds to 60 seconds, what this case is about, what your client wants, and on what basis your client says he or she is entitled to the court order that you seek. So you've got to get that part right to immediately inform the court as to what it is, why you're there, what you want, and on what basis you can ask for it. All of that involves being prepared. At more advanced levels, there are issues to do with the way in which you ask questions in cross-examination or examination in chief, but it's all part of the issue of preparation. It is important to be concise. Now, that may surprise you. If you've looked at TV dramas or you've been into a courtroom many years ago, it may have appeared that lawyers would embark on long, rambling monologues using as much Latin as possible, it would seem, and referring to cases and legislation in a cryptic manner. But that's certainly not a modern approach. So the modern approach is be prepared, then once you're on your feet, be concise. Now, that's not just a rule of practice. There are legislative requirements now for you to minimise the time that you spend in court to ensure that the court time is used efficiently and wisely. So being concise is part of the professional obligation. One technique that I like to adopt, and I think many do, is to state the conclusion and work back from that. Now, that may seem familiar from what I said in week 1 as my guide to what you should do as part of your studies. I said, look at what you ultimately wish to achieve and then plan back from there so that you can reach that conclusion after having essentially identified what it is that you need to achieve at an early stage. It's like that in court proceedings. So in court proceedings, I will often say, and barristers and solicitors will often say, this is what I seek, and then work towards that. In other words, you're immediately addressing what it is that the court wants to know. When you're taking your instructions, you need to do so in a way that you can rely upon when you're under pressure in a courtroom context. So when you're on your feet, when you're involved in courtroom advocacy, that's not the time for you to be endlessly, it would seem, flicking through papers, trying to read your writing, looking quizzically at papers thinking, I wonder what I meant by that when I took the notes. So as you're taking your instructions and then preparing for court, you need to ensure that you have those in a form of a reliable form and that you can rely upon that when you're under pressure. What's the next thing about courtroom advocacy? Well, you need to undertake your research. Now that brings us back then to the week 5 discussion rather, about legal research skills. And I do hope on that point that you have extensively looked through the online free resources, that you've looked through the online paid resources through the Central Queensland University Library, and that you have looked very carefully at, say, the legal research videos that I prepared. So please ensure that you understand and you can undertake legal research. That's an important skill, of course, in courtroom advocacy. The next thing with courtroom advocacy is generally have the law accessible in written form. Now, by that I mean something that you intend to hand up to the judge. So if, for example, you're referring to Section 55 of the Property Law Act, it would be polite and appropriate to at least have a copy of that section from an authorised source that you can provide to the court, so the court has an opportunity to read that on the go. Now, in some jurisdictions, we have courts and judges with computer access immediately in front of them. So if you go to the federal court, you'll see that judges now have these huge screens in front of them, and it makes so much sense. And it goes with the e-technology and the paperless technology and paperless courtroom advocacy that we're looking at. So it becomes less important in those circumstances. But generally speaking, unless it's something that magistrates or judges are dealing with on a daily basis, you need to have something available for the judge to look at, and of course your opponent to look at if you're going to refer to it. And that's typically cases and legislation. When it comes to courtroom advocacy, there is another important skill, and this is really very important for your credibility and to assist you in ultimately obtaining what you want. And that is skillfully and appropriately having the ability to make concessions or consider alternate arguments. So when I say a concession, I mean an ability to say to the court, quite frankly, yes, I concede that point and I concede my opponent's argument, but I still urge Your Honour to consider to provide a conclusion contrary to that for these reasons. So you need to consider and make concessions where necessary. Courtroom advocacy is not just about oral delivery. There is great scope for written submissions in courtroom advocacy, and indeed it's very common and I think appropriate to provide written submissions either before the court proceedings or during the court proceedings to supplement that which you wish to say. And they're different. What you may put in a written submission will not be what you say on your feet. There's a different emphasis. When you're on your feet, you're emphasising the main points, you're hammering home the logical arguments that support your ultimate conclusion, and the written submissions go into more detail, provide authority for decisions or propositions that you may not refer to specifically when you're on your feet. So they're very different, but the two work in conjunction. So consider preparing and submitting written submissions or handing up written submissions, and maybe even a draft order. If you're seeking a declaration as to the existence of some factual situation, then when you're on your feet or before the event, hand up a draft order and say, here's the order that I urge Your Honour to make in these circumstances. Okay, so when it comes to courtroom advocacy, let's go back to the start now. I've talked about the general principles. How does it work in practice? Well, the first thing that one must do is announce their appearance. What that means is to say formally, here is my name, my legal profession, whether I'm a barrister or a solicitor, who you're instructed by, who you act for, and that's the formal appearance. So in my case, it might be, my name is Milburn, M-I-L-B-U-R-N, initials J-A, counsel instructed by Smith Lawyers, acting for the plaintiff in these proceedings, something along those lines. What we see a lot in courtroom advocacy at the start is people rush. And it is important that you be concise, but part of being concise is being prepared. And part of being prepared is to instill confidence in your abilities while you're on your feet. And when you're confident, you're less likely to be rushed. And rushing sometimes occurs as a result of nervousness or lack of confidence. So you can see how these things flow together. But the golden rule is don't rush, but do be confident. When we talk about courtroom advocacy, there are a number of different examples that I could provide to you. One is in a civil context, an application to set aside a judgment. So if your client comes to you and says, look, I was sued, I failed to provide a defence quickly enough, the other side have now taken a judgment against me in default of my appearance, there's an application available to you in those circumstances to apply to set aside the judgment. And if you do that, you need to show an arguable defence. You need to set up good reasons for the delay. You need to consider whether there's been any prejudice to the other side as a result of your client's failure to provide the defence straight away. And then you need to make a concession. I talked about concessions earlier. An appropriate concession in those circumstances would be to say that your client has provided you with instructions to offer to make payment, to your opponent for the costs, the legal costs thrown away as a result of your failure to file a defence within the appropriate time. And that term thrown away, cost thrown away, is actually a technical term that you'll hear quite often. So that's one example of courtroom advocacy in a civil law context. Another is in a criminal law context, bail applications. Very common, of course, and the starting point in the context of knowing the law is to determine whether or not this defendant is in what's called a show cause situation or not. In other words, who has the onus here? If the defendant is charged with an indictable offence whilst already on bail for another indictable offence, then the onus of whether to grant bail or not goes back onto the defendant. So if however, the defendant is charged with a simple offence, then the general onus is on prosecution to establish that it would be appropriate and necessary in these circumstances to deny bail. So the starting point can be different, and from a technical point of view, we call that whether or not the defendant is in a show cause situation. So what would you do if you're preparing for a bail application from a practical perspective? I've mentioned that you need to be prepared, you need to be concise. So what would you need to consider in the process of being prepared? Well, I think if your bail application involves you making statements to the effect that the defendant is a person who has good standing in the community, has a place to reside, has employment, has a good track record of assisting in the community generally, then you support these things by written documentation. There might be references or letters, certificates. There might be a copy of a lease or a copy of a rate search to show ownership of property. Things of that nature to support what you're saying can be very important, and it all goes to preparation. You might also consider whether there is a written objection to bail by prosecution, and if there is, you should consider in your address deal with each one of the concerns as outlined by prosecution. Obviously, you need to consider the criminal history. Now, the magistrate or the judge dealing with the bail application will know about the defendant's alleged crime, but also about the defendant's criminal history. Now, that is something which is kept from the jury when the jury is making a deliberation about guilt or innocence. But at the bail application hearing, the judge or the magistrate will know about the criminal history because the prosecutor will provide that criminal history. Now, just an aside on ethics, if the prosecutor fails to provide a criminal history or fails to provide an up-to-date criminal history, then as defence counsel in courtroom advocacy, you're under no obligation to correct the situation. You cannot make submissions that directly contradict what you know to be the truth, but you don't have to assist prosecution by volunteering information in that regard that would be contrary to your client's interests. What does the magistrate want to know, and therefore what is the appropriate part of court advocacy for a bail application? Things like, does your client reside in a certain address? Has your client been there for long? What is the state of their tenure? Who else is in the house? Does your client work? What's the employment history like? And what do you have to show for that? And you may have to offer reasonable conditions as well. So, for example, depending on the severity of the situation, you may have to offer a surety, or you may have to offer a curfew, or perhaps an undertaking not to leave the state, maybe to volunteer a passport, things of that nature. So as part of your preparation for a bail application, you'll be considering what might be reasonable conditions that might be imposed. And just finally, on courtroom advocacy, a word about cross-examination. I'm also privileged quite often to take the unit evidence, which is a third-year subject, evidence and proof, and we do have some practical exercises on cross-examination. So cross-examination is where you as the courtroom advocate have an opportunity to attack the witness that has been presented by your opponent, whether that's the Crown or in a civil proceeding, say the plaintiff or the defendant. So when you're attacking the opponent, there are some key rules. One of the first is keep your questions short. Also, keep them understandable. When you're watching TV and you're watching an interviewer, even a well-regarded journalist of many years' experience, I'm amazed at how often their questions are lengthy, that they ask multiple questions before asking for an answer. That's completely different to a good courtroom technique. So in courtroom, in cross-examination or examination in chief, you're often working on a building block type approach where it's simply one step at a time in quick succession. In doing that, you're avoiding double negatives and you're avoiding double-barreled questions. So if you're looking to attack some evidence, you might say, were you driving a car? Yes, no. If the answer was yes, was the car red in colour? Yes, no. If it was yes, did you own the car? Things of that nature. As opposed to asking, did you drive your own red car on the day? Can you see how that's like a double or triple barreled question? You're not building step by step in that situation. And the question, therefore, in those circumstances would be objectionable. And it's a real art to learn how to do that and implement it, because naturally we don't keep questions short and build one after the other, partly because it feels like an interrogation. So when you see a journalist on TV asking questions of an interviewee, it may seem much more natural and conversational, but it's not the way lawyers communicate in a courtroom advocacy context. Okay, that's enough about oral communication. So I'm still on week 6 material. Some thoughts about written communication. When preparing written communication, the number one starting point, which is very similar to oral communications in a courtroom context, is to be prepared, and I'll say in this context, plan your thoughts. Have an idea of where you're going. And from a practical perspective, one of the very good ways to do that is to use headings. Now, you may not leave the headings in your final draft, but often you do. In many legal letters, we have headings throughout, and it's a perfectly acceptable and I think appropriate manner of drafting legal written communication. This might be in a letter to a client, to an opponent, or it might be an opinion, it might be a deed, a lease, it might be some other form of written communication. So there's nothing wrong with headings. In fact, I think they're very useful. If you prepare headings, then of course it demonstrates that you're planning your thoughts, doesn't it? Now, one thing that's really important to me, and this is something that I do want you to be very conscious of, is professional presentation. Now, when you're presenting something in written form for legal matters, it's generally professionally understated rather than overstated. By that I mean it's not something that you would spend a lot of time in decorating with, I don't know, just for example, with borders or with, you know, scroll or special font. So it's kind of professional, minimalist type presentation. But the important things are it needs to be consistent throughout the document. Don't change fonts arbitrarily. You might change the size of font, particularly drop the size of the font by 1 if you're quoting something direct in a standalone paragraph. Make sure that it's paginated, make sure that you use appropriate headings, that the headings are consistent, and that it's all logical. Make sure that you use footnote referencing in accordance with the Australian Guide to Legal Citations. If you have any concerns, please read my sample document. Please read my guide to written communication. You'll find this in Moodle, I think probably under other resources or maybe even assessment, but do make sure that you are familiar with that. So from a professional presentation perspective, I think the key is this. Have a look at what others have done as part of your reading, and you'll get an idea of what I mean. Secondly, and this is very important, make sure that you are aware of and use appropriately the technology available to you in terms of things like styles, headings, creating hyperlinks, footnote referencing, table of contents, etc. One thing that you will not see in legal writing typically, and it's not part of the AGLC, is bibliography. So you don't need to include that. If you're referring to a text, for example, or a case or a statute, then deal with that in the footnote reference, not as an endnote and not as a bibliography. In first year, if you put in a bibliography, I'm not going to mark you down for it, but it is important that you're aware of the need for professional presentation in the way in which is generally accepted, so that when you move on to second and third year, you are immediately creating the right impression with your examiner in terms of your presentation of material. I'm really stressing this because it's very important to me, and I'll be very disappointed if people present material that doesn't sit comfortably with what I regard to be professional presentation. Please keep that in mind. Written communication needs to be well referenced. When you refer to your material, you are acknowledging the source of the original material. You're complying with your obligations to ensure that you're not involved in plagiarism, and that you are footnote referencing those things appropriately. So your material needs to be well referenced. Your material needs to be logically written. There has to be a flow to it. So even though it's a legal document, it doesn't mean that it's a license to do whatever you like. It's still got to be readable. So it's got to be logically written. Now, as a default, when preparing written communication, I'm going to suggest to you that you consider short sentences, that you consider understandable content. There's nothing wrong with long sentences, don't get me wrong here. And you can mix up the pace by using short sentence followed by a long sentence. But where I've seen students consistently go wrong is where they attempt to use long sentences. They become jumbled, difficult to understand, and sometimes internally inconsistent. So short sentences written in the active voice is a way of resolving that issue. I know I've mentioned this many times already, but it is important. And bear in mind that when you're involved in written communication, you now do have a professional obligation, and I think I can say it's as strong as that, to be concise, to write plainly, and this is an acknowledgement of the importance of the plain English or plain language movement in law over the last 30 years or so. So you still need to write plainly, you need to write concisely. I urge you to consider the use of short sentences. Have a look at my sample document and or read something by Hemingway. I've mentioned a number of times, write in the active, not the passive voice. You should know what that means. You should have done some research by now, but let's just take an example. Here's something that I like in terms of a writing style, active voice. Here's the example. Jim told the tribunal that the victim lost consciousness. Very simple, tells the story. I know who's the who makes the statement, who's the recipient, who is the subject, and what happened. Now, compare that with this sentence, which is in the passive voice, which I think is harder to follow. The tribunal was told by Jim that the victim lost consciousness. Now, you might say it says exactly the same thing, but you're starting with the recipient first, and then you're introducing the active party second. So you're having to change your mindset. Jim told the tribunal, as opposed to the tribunal was told by Jim. Go with the first, not the second. In legal writing, avoid capitalizing and underlining more than you need to. I often see over-capitalization. Now, in law, there are some things where I expect you to capitalize. So if, for example, you're referring to the Succession Act, the word act will be capitalized in that circumstance. But most of the time, people over-capitalize. So if you're saying something like, I submit that the contract is void, why would you capitalize the word contract? The answer is you wouldn't. There is a technique that often lawyers use of capitalizing a word that is defined in the document, and that might be regarded as an exception to what I've said. Bear in mind that these days we do not use old-fashioned terminology, particularly Latin. When I first started in law, I would read a letter from a colleague, and it would say something like, I refer to your letter ultimo, or I refer to your letter instant. And I'm thinking, what do they mean? So we don't say that sort of thing. I'm not going to tell you what it all means because I don't want you to use it. But just write plainly. If you mean to say, I refer to your letter from yesterday, say that. Express some terms. You need to have some technical knowledge and use the technical terms in many circumstances. So, for example, you need to know the difference between a mortgagee and a mortgagor. If you're getting confused on that, just here's a quick guide. As an aside, the mortgagee is, if you like, the lender. So there's the double E in mortgagee at the end, and there's two E's in lender. Mortgagor is the borrower. So there's the OR sound in the middle of borrower, and there's the OR sound at the end of mortgagor. But probably the easiest way to remember it is a little rhyme, and that is the mortgagor is always poor. Not always, but you know what I mean. So the mortgagor is the borrower. The mortgagor is always poor. So what are some common legal documents that you need to consider as part of your legal writing skills? We've already talked about file notes, and we did that in the context of taking instructions from a client. So you need to develop the skill of taking those notes appropriately. And I actually use headings when I'm preparing file notes. I use voice recognition. I mentioned that previously. Witness statements can be difficult. If you're taking a witness statement directly from a witness, then quite often you need to engage in what is effectively an examination in chief exercise, where you're asking questions, eliciting responses, then in my case using voice recognition to record the words, using where possible and to the greatest extent that you can, the actual words used by the witness. It's their statement, not yours. And by using the voice recognition, repeating back and saying, all right, so what you're telling me is this, start to record, blah, 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 blah. It gives the witness an opportunity to say, yeah, that's what I'm saying, or no, you haven't quite got it right, and then you can reword it. So witness statements you need to do. Affidavits, statutory declarations are all legal documents that you need to do. And you also need to consider things like opinions or advices. So I know I've been doing a lot of talking today. We're still on week 6 material, but what is it about presenting your material orally or writing that's important? Well, it needs to be concise. It needs to be well prepared. It needs to convey the message in a simple but effective a manner as possible. Written communication needs to be on time, and that's reflected in my philosophy with assessments, that if you don't present your work on time, you will be punished. And other than the first assessment in Introduction to Law, every one of the assessments that I set has a final cut-off date. So if you don't present the work within 9 days, you won't get any marks at all. So there's the added incentive for ensuring that you present your work on time. How do you do that? How do you make sure of it? Well, look at what you need to achieve and work backwards from there to give yourself plenty of time to do so. Do look at my sample document. Make sure that you're aware of the power of, say, the Word program in preparing documents. So if you don't know how to create a document using the styles built into the Word program, please learn that now. If you don't know how to properly proof a document, then please do that now. And that might mean looking at the proofing proofing techniques. That you go to top left-hand corner from memory, files, then options, then proofing, proofread your document. Do avoid lengthy sentences, and do try to write in the active voice. Now, one little thing which is a big bugbear with me is finishing sentences with a preposition, and do try to avoid that. We see it off actually a lot in general language, but in legal documents, I think we can do better. So what do I mean by that? Prepositions are words that introduce information to the reader. For example, in or to or from or for or with. So try not to end a sentence with those type of prepositions or any preposition. So to just give you an example, the DVD is in the brief is an example of a prepositional phrase. The word in is the preposition, the word brief is the object. So try to avoid ending the sentence with the word in those circumstances. And do also avoid abbreviated language. Another little bugbear of mine. All of this is designed to ensure that you write in a professional manner, a manner that looks the part and will please your examiners in second and third year, as well as me, of course, in first year. So do not say don't, say do not. I know it's 2 words and you might say, yeah, but we were looking for simplicity. Why use 2 words when you can use 1? Well, the answer is that's an exception. So avoid the use of abbreviated language. Also, try to simplify your language where you can. Take this example. I read through it. To say I read it, why do you have to use the word, introduce the extra word through? Now you might say it won't make a lot of difference, but bear in mind, of course, that what we're looking for is simplicity where possible, and that means particularly if the word count, if you go over a word count, I'll be looking for any words that you didn't need, and you'll be marked down for it to a greater extent. A couple of other tips: take care with the use of the possessive apostrophe. Whether you put in an apostrophe at all, whether you put it in before the S or after the S, singular, plural, things of that nature. And unless you're writing in a heading, make sure that you write a complete sentence. I'm surprised the number of students who don't do that. Now, of course, when it comes to writing, you also need to have a very good grasp of referencing material, the Australian Guide to Legal Citations. You will need to understand and use pinpoint referencing. So identifying, for example, a page as part of the AGLC. So if you don't know the AGLC or have a good basic guide on understanding, stop the video and find it now. There should be an opportunity to use the footnote referencing technique in Word program. If you use it correctly, what you'll see is that the footnote font is actually a smaller size as it should be than the font in the body of the document that you're referring to. Now, I have some personal preferences which might be idiosyncratic, but there are many situations where you need to comply with industry norms. So, for example, if you're typing legislation or case law, please type that in italics. It drives me crazy if I don't see that. It's part of the appropriate way of referring to a case or to an act. Now, not the entire case, just the name of the litigants are in italics, the rest is not. I've already spoken to you a couple of times about what I believe to be the benefits of voice recognition software. One thing that I will suggest to you is that it is useful in the sense of providing with advocacy practice and efficiency. So I've mentioned today, for example, in preparing a written document, you need to prepare your thoughts. If you're using your voice to prepare the material, it's more likely that you have to prepare your thoughts before you start to speak. I know a lot of people are trained as touch typists, and they'll say, but that's the way I work. If you're going to type your material, which is fine, and I know that 99% of you will do that, rather than using your voice, I just ask for one thing, and that is read through the material so that it makes sense in its written form rather than just on paper. And that often comes back to the length of the sentences. And I do get the impression that sometimes when people are preparing a law assignment, they have these various thoughts that are going through their mind and they just keep typing. And before you know it, the sentence is very long. Now that can work with oral presentation as well, but just ensure that there's an efficiency there. I know I'm not getting on to week 7 material, which is to do with interpretation. We'll be 1 week behind. I appreciate that. But before I leave this issue of communicating as a lawyer, I want to touch base with you on a very important topic, and that is the difference between collaboration and collusion/plagiarism. So what is collaboration? And why is it acceptable when collusion is not acceptable? Well, collaboration means working with some other person or some other people, usually part of your study group. We want you to support each other. We do want you to work together. I don't mind if I give HDs to every single one of you. I'm under no obligation to follow a bell curve. I'm under no obligation to make sure that only a certain number of people get HDs, etc. I'm a pretty hard marker. I acknowledge that. We won't talk about the converse, but you understand what I mean. So, collaborating. What that means is that you can work together in planning material. You can cooperate with each other. You can empathize with each other. You can talk about your difficulties, successes. But if you're going to work in a collaborative arrangement with someone, whether it's formally as part of a group assessment or simply collaborating on an individual assessment, the golden rule, I think, is this: aim to give more than you receive. Aim to give more than you receive if you're working collaboratively. And in the new lawyer, you'll see an example of a group contract. I'd refer you to that. So what does collaboration actually mean then? It means that you can discuss with others the issues that might be raised by an assessment. So, for example, in an alternative, was it alternative? No, I think it was a statutory interpretation exercise that I wrote. It was a short paper. I encouraged collaboration, and one of the students said, all right, well, in that spirit, what I'm going to do is host a session. This was Nicholas McIntosh. I'm going to host a session, and everyone is welcome to drop in, and I was welcome to attend, but I didn't want to. I think I may have popped my head around the corner, so to speak, and said, hi, good move. And the idea of that was it was a session between a number of students. In fact, I think it ended up being more than half the class, where when the take-home paper was released, people spent an hour saying, well, what do you think the issues are? What are the issues that are raised by this assessment? And then started to talk about, well, what are the ways that we could identify and deal with these issues raised in the assessment? There's nothing wrong with that. Some people might say, well, we could do it this way, we could do it that way. And you can certainly share the location and sources of information relevant to the assessment. So someone might say, well, I think, this case or this section might have a bearing on this form of assessment. So all of that is permissible collaboration. But what you can't do is you can't then be more specific in planning, the structure of someone else's assessment. You certainly can't write their assessment. You can't provide a copy of your work to the others. So all of that then becomes impermissible. I hope you understand that difference. So let's wrap up this evening with something about mediation, because mediation provides some commentary about effective communication. And if you're mediating, you need to be dynamic and lively as the mediator. You need to focus the parties on trying to resolve the issues. You're reality testing. You're thinking about the best and the worst outcomes that are available to them, and using your advocacy skills as a mediator by asking open, clarifying questions and to some degree testing what is being done. And all of that's a little advertisement for ADR. Thank you very much for your attendance this evening. Enjoy the rest of your festive season, your new year, and we'll see you back on deck for week 8, which will cover week 7 material on the 7th of January, Monday the 7th of January. All the best for now. Bye.